Under Oklahoma law, a product can be defective in 3 ways. And importantly, if a product is defective, the manufacturer of the product is strictly liable for any injuries caused by that defect. The 3 types of defects that can be in a product are a manufacturer's defect, a design defect, or a failure to warn. A manufacturer's defect is where the design of the product is just fine, but there was a defect in the manufacturing process. For example, a seat belt. A seat belt on a Ford Taurus may be just fine in the way it was designed, but in your particular car, the seat belt had a defect in your car. That would be a manufacturer's defect because something happened during the manufacturing process in your car. And if you suffered an injury as a result of that defective seat belt, you would be entitled to recover compensation for your injuries. A second type of defect is a design defect. A design defect is where the design of the product itself is bad. For example, a saw that could have a guard on it to protect you from getting injured when you're using the saw would be a design defect. Many years ago, some saws in workplaces did not have certain types of guards on them that they should have and could have had at very little cost to the manufacturer. When people got injured by those saws, they brought claims saying that there should have been a guard over the saw to protect and prevent that injury. Many lawsuits were successful in prosecuting those manufacturers for failure to have a guard. That was a design defect. And now most saws you see in workplaces and different types of tools like that used in industry do have protective guards. Another type of defect is a failure to warn. A manufacturer has a duty to warn consumers when there is a danger in a product, so the consumer knows how to use the product and knows what dangers are in the product. An example of a failure to warn case is in drug liability cases. Oftentimes, drugs that are prescribed drugs will have certain dangers, and sometimes the manufacturer does not warn or does not adequately warn the consumer of that danger, that the drug will cause a certain condition, and then the consumer gets that condition, which can be catastrophic, and the manufacturer, because it did not warn the consumer of that danger, is responsible for the injuries caused by that drug. So those are the 3 types of manufacturers, or 3 types of defects in a product: manufacturers, design, and a failure to warn. Now, a lot of times a defective product case arises out of the workplace, where someone may be, especially in an industrial setting, may be injured because of some piece of equipment they are using at the workplace, and they have a right to receive workers' compensation as a result of that injury because they were working on the job at the time of the injury. But the injury may have been caused by a product that they were working with that was manufactured by somebody else. And so there may also be a product liability claim in that setting. If you have questions about product liability claims or workplace injury claims, please give us a call at the Nix Law Group at 405-509-2000 or visit us at our website, oklahomainjurylaw.com.